that. And next, we're going to be exploring the UI application process and ID.me. And we've had a lot of calls about ID.me because clients are like, what is this? It is something that was newly implemented after so many instances of fraud during the height of the pandemic. So some materials about that would be so helpful. Next, negative determination. So that is what happens when someone applies for benefits and they receive a denial. So there are many reasons why someone can receive a denial. So we'll go over that. And the types of jobs. So there are many different types of jobs that clients can apply for unemployment, but they're not exactly sure if they'll be eligible for it, especially if they don't receive a W-2. They might be a 1099 worker, independent contractor, adjunct professors, small business owners, and partial employment. And then these are some of the jobs that we are hearing a lot of questions for. You know, do I qualify for benefits? You know, they aren't really sure. And it would be helpful if they can just see like a one-pager on that info. That would be really helpful. Next, clients collecting Social Security, disability, and insurance, pensions. There are different qualifications on whether or not someone can receive unemployment along with these extra benefits. So just something client-facing to inform them about this and the restrictions on that. Next, registration, certification, and reporting, and basically recoverability of benefits after a significant period of time that they aren't claiming. And lastly, we'll go over a Q&A. I'm going to turn it over to Tori to go over this overview of benefits.
Thanks, Adama. And I will remind everyone that while we are going to talk about some substance today, there is a lot more information to be researched. All of the information in this PowerPoint is not the totality of the information about some of these things, but we do think that it's helpful to give an overview about some of these considerations. So what is unemployment insurance? What are we talking about here today? The New York State does offer unemployment insurance benefits to those who lost their job through no fault of their own. In fact, employers pay into unemployment insurance through taxes, both state and federal taxes. So a claimant applies for unemployment insurance benefits after they've lost their employment by filling out an application either online or over the phone. Truly, and something that we will repeat throughout this presentation, is that there is a claimant handbook. Part of the reason why we are seeking resources from you is that this handbook is a little bit hard to read. It is very long. It's hard for claimants to understand. However, they are responsible for much of the information that is in that handbook, and that information is super important when it comes to claiming. So that is what the claimant's start point is supposed to be. Claimant handbook has a lot of the information, and I certainly suggest utilizing it yourselves as we talk about some of these issues. So in order to qualify for state benefits, there are several hoops that claimants have to jump through. We want to make these hoops clear in our materials, right? That you have to meet all 4 of these standards. Otherwise, you will not be able to collect benefits. I think claimants sometimes understand that, yes, you had to lose your job under qualifying circumstances, perhaps that there's a wage requirement, but truly, claimants need to meet all 4 of these standards listed here. You've lost your job through no fault of your own, that you are ready, willing, and able to work, that you've earned enough wages, and that you're actively searching. So the goal with these materials is to make it clear not only what these qualifications are, but that claimants must meet all 4. So that first requirement, that you lost your job without fault. So if you're laid off, or if a claimant loses their job due to a reduction in force, if the company downsizes, or if the company that you work for shuts down, claimants are going to meet this requirement, right? This is what happened to many during the pandemic. So this is not a situation that we hear of very often anymore, but that is the simplest, like lost your job without fault. Eligibility could also mean that you were terminated due to not meeting performance productivity standards. So if you're just not, if you're a salesperson and you're not reaching quota, you may be eligible because you're not at fault, right? You're not meeting productivity standards. Of course, everything operates on a case-by-case basis. And our hope with these materials is not just to give some examples, right, of like who would be eligible and who would be ineligible, but also to clarify that Everything is on a case-by-case basis. And of course, employees who are fired for work-related misconduct, which we'll talk about a little bit later, you may not meet that standard. So that is someone who will not meet that first requirement that you've lost your job without fault. This second requirement, being ready, willing, able to work, really just means that the claimant has to be prepared to start a new job immediately. In terms of what sort of new job, and again, the Department of Labor has some additional resources on what sort of jobs claimants should be seeking, because there are time periods that are accounted for. After a certain amount of time, claimants can open up their search to a wider range, but generally speaking, the Department of Labor requires that you are able to start work in your usual employment field or in any other field for which you're reasonably fitted by training and experience. So being able to work doesn't mean that if you've worked as a waitress, you now can start working remotely for a data entry firm. That's not where your experience is. That's not your usual employment. So again, utilizing examples is something that we're hoping to see a lot in these materials so that claimants can better understand how some of these rules apply to them. In addition to being ready and willing, claimant must be actually able, meaning that they are physically capable of working, and for immigration purposes, that they are authorized to work. In other words, that they have work authorization documents. That third requirement, that the claimant has earned enough wages. Again, there is a lot of information about this on the Department of Labor's website. But again, in order to qualify for benefits, you just have to meet these three earning requirements. You have to have worked and been paid wages in jobs covered by unemployment insurance. And we'll talk a little bit later about what jobs covered by unemployment insurance means. You have to have earnings in at least 2 calendar quarters. The Department of Labor makes determinations about earnings based on quarters. So you have to have earnings in at least 2 quarters in order to qualify. For claims filed in 2022, claimant has to have made at least 2,900 in 1 calendar quarter. That number is raised almost every year. We are anticipating it will change in 2023. This is what it is right now. And then that the total wages paid to you must be 1.5 times more than the wages earned in your highest quarter. Again, some of these are a little bit more nuanced than we're going over today. And there are some charts and there's more information from the Department of Labor about how they calculate if you have enough wages. But this is, again, an overview, and we're hoping to really simplify this for claimants so that it's more accessible. This is a base period calculation chart. We are definitely hoping for a chart that looks not like this. Maybe is more readable, maybe it's more understandable for claimants. But this is right now what the Department of Labor shows claimants, which again, is just sort of difficult to read and difficult to understand. But as you can probably glean, like there are certain quarters that are accounted for, other quarters are too far back or too close to the application. So again, just looking to simplify this information and make it more accessible for claimants. And finally, this last requirement, that the claimant must actively be searching for work. The Department of Labor has work search requirements. Claimants have to keep records of their work search, and they have to do 3 work activities each week. This is something that claimants often feel that if they don't keep records, or perhaps if they're doing some work search, that they'll be okay. The Department of Labor does check in. They randomly audit, they will call, they will schedule meetings to make sure that claimants are in fact actively searching for work. So if you're not actively searching for work, or if you're audited and you can't provide work search records, claimants' benefits might be stopped. So again, there's more information here than what I'm saying right now, but we just want to make it clear to claimants that all 4 need to be ongoing, right? So if they're not actively searching for work for one reason or another, might not actually be eligible for benefits. And I'll turn it back to Adama. Adama, you are muted.
Yes, thanks. All right, so we want to make it very clear to clients, letting them know how do they apply. The process is pretty simple. It's either online or over the phone, what information that they'll need when applying. Now, this is something that some clients might not know. They think they can just start the process. And if they answer the questions incorrectly, that can be a no-go, right? Because ultimately the Department of Labor does hold them up to that standard of, hey, this is what you told us. If you lied, that can be an issue, right? So just emphasizing that to clients, because especially with the pandemic recently, the overpayments that were resulting from that, many clients didn't even know it was possible that they can be told, oh, you were overpaid benefits and you need to pay the Department of Labor back hundreds of thousands of dollars. They didn't know, and we really want to emphasize that to clients in any materials that we provide. Next, we'll be going over ID.me. And again, that's something that many clients didn't know about and have had some difficulty with as well. And lastly, we'll be going through immigrant eligibility. And next slide. Oh, next slide. All right. So how do claimants apply? Ultimately, they can apply either online or over the phone. They can, if they don't speak English, there are multiple other languages that they can get a translator for by calling that number there. And we want this to be as accessible to our English-speaking clients as it is to our, clients who speak other languages as well. Just letting them know that these resources are available to them, because oftentimes we speak with people who say, hey, I didn't actually know that this was available in my language. So we definitely want clients to know that there are opportunities for them to read these documents in their language. And if there is, let's say, a mistake that's made during the application, it's not due to, oh, someone was, helping me with it. It's because, another issue. But ultimately, we want them to know that other languages are available and accessible to them for applications and questions that come up. Next slide. All right, so what information is needed? They should have their social security number on hand, driver's license, mailing address, and this is just a list, but ultimately there are other things as well that they could have on hand. Just ultimately anything that will be helpful to them to prove their finances and that they were working, anything like that will be helpful to them. And like I said, sometimes I speak with clients who do not know, oh, what was the last day of work? They'll say, oh, I have to look back. They should have that information on hand. And we just want to emphasize to them that if the information they're submitting is incorrect, there can be an overpayment and they could be deemed at fault for that. And there could be penalties involved in all of that. So really just want to emphasize to our clients that they should have this on hand. Next slide. All right, so ID.me, this was actually, ID.me is a private organization, and the New York State Department of Labor contracted with them so that they could assist with verifying people's identities. During the height of the pandemic, there were so many instances of fraud that they had to use some type of additional measure for verifying applicants' identities. So they used ID.me. There have been some issues, especially with clients who are not so technologically advanced. So they have had questions about that. And we'd like to know if this is the only option, and if they do have to use ID.me, if it's just a very clear and concise way of letting clients know the best way to use it and how to get assistance with that. Next slide. All right, so for the application, it's important to emphasize that, they have to provide the answers that are the truth and not just what they think the Department of Labor wants to hear. And ultimately, like I said, if they provide any false or inaccurate information, they will be deemed at fault for that. And if there is any pertinent financial documents, they should have it on hand during the application process. All right, next slide. So after clients submit their application, they'll receive either a approval or a denial, and someone from the DOL may reach out to them to obtain further information. It's important that they respond as quickly as possible to any request. The DOL typically reaches out to clients, their previous employers as well. And in those instances, they'll try to figure out, hey, what was their salary and all of that type of information? How did their employment come to an end? And that's one of the biggest factors, because sometimes a client will say, well, I was fired, but actually they quit. So little things like that can make a big difference in their application. And if there's a negative determination, they can request a hearing on that matter. And ultimately, they're going to hold them to what they said before. So it's just important that all the information that they provide is accurate, and we really want to emphasize that to them. So processing times can sometimes take up to 2 months or so for the application after it's been submitted. The DOL actually makes the determination on eligibility based on the assessments of the eligibility along with those 4 factors. So they meet those 4 factors that were mentioned earlier, and they make it also depending on the UI law as well. So once the Department of Labor makes the decision, they mail that out to the clients via mail, and if they are successful, they'll receive monetary benefit determination. If they are unsuccessful, it's important that clients know that they only have 30 days to request a hearing after that. So just emphasizing that clients, they have rights, even if they were deemed ineligible, they can still fight that and request a hearing. That information would be helpful as well. Next slide, please. All right, so how do clients receive benefits? This is pretty standard, but they receive it either direct deposit or key bank. And every week they have to respond to questions, doing weekly certifications, and they can do so either online or over the phone. And again, truthful. They have to be as truthful and accurate as possible, because unfortunately, we've gotten a lot of calls where clients who said, oh, I just said no to everything, but then that wasn't actually the case. And then it comes up as an issue later and then overpayment, right? And we don't want that. We want to prevent that as much as possible. All right, next slide. So for UI eligibility for immigrants within that context, in the initial application, the Department of Labor doesn't really ask whether or not they have work authorization, right? What actually occurs is they just say, were you ready, willing, and able to work? So it's important that clients keep that in mind. If they do not have a up-to-date work authorization, they wouldn't really be considered ready, willing, and able to work at that point in time. So they wouldn't be able to qualify for that. So it's just important that clients keep that in mind when they're answering these questions. And it's just important that we emphasize that they have to have had a valid EAD in order to collect UI benefits, because oftentimes they may not know. So it's important that when they're applying, they look for the expiration date of their EAD and make sure that it is within the accurate time frame to make them eligible for UI benefits. All right.
And just to continue this discussion about eligibility, and again, we're hoping to sort of put eligibility all together. After a claimant makes an initial application, that claimant has to certify every week in order to continue receiving benefits. And we'll talk about certification in just a moment. Now, what's important for immigrants as part of this process is that the Department of Labor does not ask at all whether or not the applicant still has work authorization when they're asking these weekly questions, or if their EAD has expired. So instead, the applicant is asked whether or not there were any days where they were not ready, willing, and able to work. So what's important is that if the EAD expires, they're no longer ready, willing, and able to work, and therefore should answer no to that question, right? So our hope is really to clarify, not only through every piece of the application, what the claimant needs to do, right? But that as they encounter these certification questions, which are the same questions that they're asked every week, again, we'll talk about this in just a moment, that answer might change from week to week. So what we suggest generally is that if an applicant has a work authorization document, an EAD, that advocates should check that application, and that claimants should be reminded to check that EAD to make sure that it has not expired. If it has expired, it does need to get it needs to be reapproved. And if their form has expired, but then they resubmitted for a new one and it's within a certain period of time, they may be eligible for an extension. So again, there's more information available online about what an EAD is, what an extension looks like, what sort of claimant would qualify. But our hope is to sort of not just put all of this eligibility information together for claimants, but also just to note that if claimants are in an immigration situation, they may be eligible for benefits. They just need to follow some of these additional steps and standards. So I am going to talk a little bit about certain types of jobs, really what we're hoping for from the next like several slides, which again, I will not go into excruciating detail. We're hoping for like some one pagers, right? 1 or 2 pages just on these like very specific issues, right? So we just talked about eligibility. Eligibility can be taken as a whole, whereas these are questions that we get from claimants who are in a more specific set of circumstances, and we want to provide them information in, again, like a readable format that's accurate, but is reflective of their specific job or their specific like working situation. So the first one that I'll talk a little bit about is independent contractors. So a claimant has to be an employee in order to collect unemployment insurance. They have to work for an employer that pays into the unemployment insurance system, so they must be an employee. Independent contractors are not eligible for state unemployment insurance benefits. Now, there are a couple ways to tell if a claimant is an employee versus an independent contractor. Again, this is not all of the information possible. The Department of Labor does have actually pretty detailed information on their website about what they consider to be the difference between an independent contractor and a W-2 employee. But some really simple ways to tell, and some things that we've noticed in hearings that come up are, if a claimant receives a W-2, if they get fringe benefits like PTO, sick time, health benefits, health insurance, or if their work is significantly controlled by the employer, like employer creates your schedule, they supervise your work, claimant is likely an employee. Whereas a claimant is an independent contractor, if they don't receive any of those fringe benefits, if they collect a 1099, if they create their own schedule, really what the Department of Labor accounts for is like supervision and control, right? So how much control does the employer have versus how much control does the worker have in terms of their work? So these are just some nuances that we want to point out, just so that it's clear that maybe even if you do collect a 1099, you may be considered an employee. So again, there's a lot of factors that the Department of Labor accounts for. So we want to make that clear for claimants who perhaps fall somewhere in the middle of these two. The next job that I do want to talk about is an adjunct professor. Claimants who are adjunct professors often face the following issues claiming benefits. So educational institution employees, which are not limited to adjunct professors, but this is often when we see them the most, either adjunct professors or substitute teachers. These are employees who work for educational institutions, and they're subject to the reasonable assurance rules of academic breaks. So in short, an educational institution employee is not considered unemployed during a natural academic break, like the week of spring break, the holiday break period, which could be anywhere between a week, 2 weeks, and maybe a month if we're talking about higher level education, or summer vacation even, which is a pretty fair amount of time. It's usually about 10 weeks, because these claimants have reasonable assurance that there will be continued work for them after that break period. So if you're an adjunct professor, you can't collect unemployment insurance in, say, that week of spring break just because you're not working. The other issue that we often see with adjunct professors is that claimants might live in New York, but say they work in a school in New Jersey or Pennsylvania or Connecticut or one of the other surrounding states. Only New York wages can be used towards a New York unemployment insurance claim. So it's important that if someone is a professor, or really, this should say educational institution employee, but this is who we hear from the most, we want to make it clear that the end of that employment must be definitive in order to collect unemployment insurance. And some of this additional information is really helpful for people who are looking for it. So the next thing I'm going to talk about is someone who we've heard a lot from, which are small business owners. Generally speaking, small business owners are not eligible for benefits. Why are we talking about this? Business owners may have been eligible for federal benefits during the height of the pandemic period when federal benefits were available, which was between March 2020, September 2021. But those benefits are no longer available. Claimants cannot apply for federal benefits retroactively. I know we hear from lots of small business owners. Many small business owners are still struggling from the pandemic, and they're seeking resources and assistance. Unfortunately, they are not eligible for regular state benefits. Here are some of the reasons why. Again, this is not everything, and there is some more information about why small business owners are not eligible on the Department of Labor's website. But I think that we can say that the main reason is that small business owners generally have difficulty proving that they have no income and that they're not working at all, unless they have completely closed down their business. So in order to collect unemployment insurance, claimant must be totally unemployed. A business that is not doing well is not considered total unemployment. So again, in utilizing examples, if a business has not, made very many sales in the last few quarters and they're struggling and they're losing profit, or if a business had to close down one of their brick and mortar stores and now they only have one store and they've lost a significant amount of income, small business owners are just not eligible for unemployment insurance. However, a small business owner or an entrepreneur who has suffered total closure of their business and is now looking to see what the next steps are for them may be eligible for SEAP, which is a self-employment assistance program to start a new business. This program is very complicated. So we've added the link here for you all to review. SEAP can quite literally be its own page because it is a fairly complicated program. Claimants do have to jump through many hoops in order to qualify for it. So SEAP is a whole situation in and of itself. Claimant does not have to be an official small business owner or entrepreneur to apply for it. I won't get into SEAP here today, but it is worthwhile to look at what the Department of Labor has on their website. It's actually fairly helpful, though we think creating clearer parameters about what claimants need to do, not only to apply for SEAP, but to hold on to SEAP would be very, very helpful. We see claimants who have somehow managed to get through that application process struggle with maintaining those benefits. It is difficult. Now, like I mentioned, small business owners not eligible. However, owners of corporations, including professional, subchapter S, and closely held corps who perform services are employees. So any compensation for these services, including dividends and distributions, are subject to contribution to the UI Trust Fund and therefore make them eligible for benefits. Again, there's nuanced information about who is eligible and who is ineligible in relation to a small business through the Department of Labor's website, and we're happy to follow up with any additional links or showing you where you can find certain information if you're confused. Similarly speaking, an individual proprietor, those earnings are not subject to contribution, so therefore their services cannot be covered by unemployment insurance. So that's a little bit about small business owners. And one of the last sort of types of jobs I'll talk about is partial employment. So like I just mentioned, generally a claimant has to be totally unemployed in order to collect unemployment insurance benefits. Here's the thing with partial benefits before I really start going into what else is on this slide. Partial benefits are difficult to collect. Claimants must be very careful. So we want to be clear in materials created for claimants that if a claimant is working part-time, it's not that they are not eligible, they might be, but claimants have to be very, very careful about how they claim and what sort of claim they're making. So when does a claimant who's working part-time become eligible for benefits? So there's two main situations that we see. Number one, that the claimant's hours were reduced to part-time through no fault of their own. Let's say the company is struggling, they don't need you to work full-time anymore, they reduce you to part-time, they no longer have full-time hours, they can only, you were working 40 hours a week, now you can only work 15 or 20, may be eligible for partial unemployment. The other situation that we frequently see is if a claimant becomes totally unemployed, and then in the process of looking for full-time work, they find part-time work, which we actually hear a lot. Claimants are just looking to take on any work that they can. So they might take on a part-time job, acknowledging that full-time work is not available for them elsewhere, or that full-time work is not available for them within that company. So in other words, if someone is voluntarily working part-time, as in they are voluntarily taking a full-time job, or excuse me, a part-time job, they could be working full-time, not going to be eligible for benefits, very unlikely. Here is what we would like to put in like flashing red lights on all materials. Claimants who are collecting benefits and working part-time must report their working hours. The amount of benefits that they collect depends upon how many hours worked. The system has changed. It used to be a days approach. It's now an hours-based approach, which is way better for claimants. However, we speak to a lot of claimants who just do not report that they're working because they're only working part-time, and that is not how this works. That is over collecting. So the Department of Labor has actually created some clearer information about how partial benefits work since the system changed. So we've added that link here. However, super important that claimants report their working hours, like cannot understate this. Again, the expectation is that a claimant is seeking full-time work and that they're only seeking part-time work in a temporary fashion. So if they are claiming part-time, must be very careful. And then just briefly, there is an intersection between Social Security, disability, pensions. It's not on here, but severance as well. Like there are other factors that may impact someone's ability to collect unemployment insurance. So what are the rules? I mean, a person is allowed to receive unemployment insurance benefits and federal disability benefits at the same time. However, they may impact each other negatively. So if you do receive social supplemental security income or SSI benefits, any unemployment benefits that you receive other than that first $20 will reduce your SSI payment dollar for dollar. So when someone is receiving SSI, they have to report all of their income to the Social Security Administration, which may include unemployment insurance. And similarly, when a person receives unemployment insurance, they have to report all income to the Department of Labor. So it's very important that if a claimant is collecting SSI, that they are reporting it to the Department of Labor, and similarly that they're reporting that they're collecting from the Department of Labor to the Social Security Administration. If you receive Social Security disability insurance, UI benefits will not affect the amount of that payment. However, if you're receiving disability insurance, you may need to demonstrate to the Department of Labor that you are in fact ready, willing, and able to work. And collecting SSDI may impact your ability to receive a favorable eligibility determination because you're collecting disability. Now for both SSI and SSDI, the Social Security Administration is allowed to consider a person's receipt of UI benefits when deciding whether or not that person is disabled. Like I just mentioned, again, if you're not ready, willing, and able to work, you can't collect unemployment insurance. At the same time, if a claimant applies for UI and is already receiving these things, the Department of Labor might determine that they're not ready, willing, and able to work. Very tricky intersection between these issues. It can be hard to tell, when someone is able to work, when someone isn't able to work. I would say that it's difficult to find a situation in which someone is collecting disability and can also collect UI.
All right, so after applying for unemployment insurance benefits, we're going to highlight some things that are important to highlight for the clients to know. So one thing is with reporting. So they have to report each week that they remain unemployed, right? So they report while they file their initial claim, but then ultimately each week they have to answer about 5 to 6 simple questions, just letting them know and letting the Department of Labor know whether or not they are still unemployed, if they started working, or if they're partially employed, they have to report how many hours they were working. All of that information is really pertinent. As Tori mentioned, it's one of the biggest amount of calls, like we get so many calls about this particular issue. It's one of the biggest reasons why people are in overpayment, because they said, oh, well, I just thought these were benefits that I was going to be receiving regardless of anything else. Ultimately, we want to emphasize that to clients, and if they fail to certify or if they were unable to do so, they should reach out to the DOL immediately, because if they don't certify and they ask later on, hey, can I receive these benefits that I should have certified for, but I forgot to, it's very difficult to receive those benefits, unfortunately. So just emphasizing that to clients, letting them know. Next slide. All right, so denial of benefits, misconduct. This is one of the biggest reasons why people receive a denial. So it might be helpful just to let clients know what could possibly certify as misconduct, and the earlier the better, especially in their application process. Maybe if they know, oh, this is misconduct, they might not even apply and not get the benefits that they are entitled to if they can actually contest that eligibility, right? So the rule is that when a client is terminated from their job, the DOL will determine whether that termination was due to misconduct or not. But misconduct isn't really defined by the DOL, but the appellate division described it to be behavior or actions that will be detrimental to the employer's interest or in violation of a reasonable work condition. So it's just really important to note that clients, they don't need to, their actions don't need to be willful or wanton to be considered misconduct. Ultimately, they can just be being negligent and it can still be deemed misconduct. And that would mean that they wouldn't be able to get their benefits. And actions or omissions outside of work may count as well. For example, we had spoken with someone who was fighting outside of the school that they worked at, and it wasn't within working hours, but it was after school and the students could see them. It just wasn't a good look and it couldn't be deemed misconduct, even though it wasn't within the confines of the working hours. And the final incident must be directly related to the termination. For example, it's important just to note that if a client loses their job for something that they did like 10 months ago, it just really doesn't make any sense. So just letting clients know that aspect as well. And employees must be aware that the action would lead to termination. So there must be a conscious awareness that the employee knew that what they were doing, the behavior they were partaking in, would likely lead to their termination. And that usually would be found to be misconduct. Next slide. Thank you. So voluntary quit. So if a claimant who voluntarily quits their job may still be entitled to benefits if they're considered to be with good cause, right? So quitting must be voluntary for a compelling reason, and in some cases, there must be analysis as to whether the claimant took reasonable steps to preserve their job. So one thing that happens in UI hearings, especially when it comes to voluntary quit cases, is the ALJ will ask questions like, hey, if this was an issue, did you speak with your supervisor? Did you try to get this issue remedied before you quit? Because if clients didn't do anything and they just said, you know what, I'm just going to quit now without even speaking with the supervisor or anything to get it resolved, in those cases, it's important for clients to know that that will likely be a voluntary quit without good cause because they didn't take any reasonable steps to preserve their employment. So some good examples of good cause are a medical reason, i.e. a doctor advises that person that they can no longer work and do their job. And it's ultimately because of, let's say, like a surgery or something of that nature. And the thing to consider with this is the ready, willing, and able to work. So maybe at one job, that person was lifting heavy boxes and they, broke their leg or something, may not be able to do that. But if that person is still able to do other jobs, then that person could still be found to have the ability to be ready, willing, and able to work. So that's just a consideration to make. Next is a change in terms and conditions. Oh, you can go back to the last slide, thanks. So next is a change in terms and conditions of employment such that the claimant would not have accepted that job initially. So if someone got a job and they were told, for example, that they would be working remotely and it was a permanent remote job, for example, and later on they're told, hey, you're going to have to go in every single day, whatever. That's an example of an extreme change in terms and conditions in which that person possibly would not have taken that job initially. And the next is relocation due to a spouse or domestic partner's employment or an employment law violation. For example, if someone just is not being paid, for example. And these are just some examples of good cause to voluntarily quit. And it's important that clients know that they can do so because ultimately, when they first hear about unemployment benefits broadly, they're told, oh, if you quit, you're probably not going to be eligible. So this is really important just to let clients know that you might be eligible even if you voluntarily quit, and just some good reasons for why. They just have to prove the good cause. And a note, the requirement that a claimant can be ready, willing, and able to work when applying for benefits often comes up for someone who yeah, exactly. So I kind of mentioned that a bit earlier about the medical reasons. So they also need to just make sure that they can, even if they can't do that work that they used to do, if they can prove that they're still able to do other work, they can make that determination and likely overcome that. Next slide. All right, so challenging the DOL and requesting a hearing. It's important that clients know that they only have 30 days from the mail date on that date of the determination in which they have to request a hearing. It's really important because we've had clients who waited beyond the 30 days and it was very difficult for them to actually get a hearing, or maybe they'll get the hearing and then the ALJ will say, well, you requested it after the 30 days, so I won't actually decide in your favor or decide at all. So timeliness is a statutory rule and it's a threshold issue. So it's just really important to emphasize that to clients, that time is of the essence. They need to request it within the 30 days. And if they do not, they have to demonstrate good cause. For example, we've seen this come up with clients who they gave their address and let's say they recently moved or something like that might be a reason for good cause. Or if the person was in the hospital, that could also be a reason for good cause for why they requested it after the 30 days. So the hearing requests on average take about 4 to 6 weeks to process, and claimants usually receive their notice between 4 to 6 weeks. So we can just let clients know in any materials that it can take around that time frame. So they shouldn't be worried if they don't receive it immediately. And claimants do not need to provide any explicit details in their request. And we actually recommend that they don't. When they're requesting a hearing, they should simply state, I disagree with the determination and I would like to participate in a hearing. The reason why we say it's best to just keep it simple for clients is because let's say if they get representation later on, they with their representative will come up with a plan for the hearing. And at that point, if it's different than the reasoning that they said in their request for the hearing, those two things won't match up for credibility purposes, and it's just best to keep it simple. So just letting clients know they should keep it simple when applying for the hearing. Next slide. All right, so a bit of info on help for immigrants or ELL applicants. So for understanding eligibility, we have a link here for the Division of Immigrant Policies and Affairs. That could be helpful just for clients when it comes to the application process for immigrants. And they should emphasize that they need to read the claimant handbook. And the claimant handbook is available in different languages as well. So it's just helpful to emphasize to clients that regardless of whether or not they read the claimant handbook, they will be held to the standards of the claimant handbook. So if it's something within there that will let them know whether or not they would have been eligible or there would be an overpayment if they did X, Y, and Z, it's just helpful for the client to know that they need to keep an eye on that before applying to benefits. Because if they receive the benefits they were ineligible for, ultimately the Department of Labor will still put the onus on the claimant who collected those benefits and it was wrongly collecting it. For language access, we have a link here. The DOL has some resources and they include a language access plan and language access coordinator and complaint forms. So that's helpful for clients to have as well. And this is just a note on the Excluded Workers Fund. Unfortunately, it is closed, but hopefully we'll have some updates on that in the future. All right, so do you guys have any questions at this point? Myself and Tori will be able to answer.
I just want to reiterate that again, we're looking for materials, a little bit of research here. So, we've talked about approximately 9 sections of information. So if you need help breaking that up, what that looks like, I don't know what your teams look like, but if you need help breaking down like what sort of information should be where, like I mentioned, some of this information is clearly like a one-pager, whereas, for instance, information about eligibility might need to be a little bit more detailed.
Thanks, Tori. Yeah, this is Chris. Yeah, we'll work with you guys and Steph to figure out how best to divvy this up. And yeah, this is extremely, obviously this is an incredible starting point. And I think we'll come back at you guys with kind of more specific questions as we dig in.
Perfect. Yeah, like we've mentioned, this is also just an overview, anticipating that you all will review these materials and then look more into some of these subsections, and then we could sort of talk about where to go from there.
Awesome.
Great. Well, thank you so much, everybody, for joining us today. Your time is super appreciated. Hopefully you found this all interesting. This is our day-to-day work. And definitely looking forward to coordinating on what the next steps will look like.
Great. Thanks so much. I hope everyone has a great rest of the day.
Thanks. You
Thank
too.
you.
Bye.
Thank you.
Goodbye.